Good morning. What is your name, please?
I'm Perez.
Page 13. Mr. Perez, you're here today to be arraigned on a charge of possession of Schedule 6 drugs, possession of a firearm with intent to go armed during a dangerous felony, possession of unlawful drug paraphernalia, violation of a no-contact order, and possession of a firearm, and possession of a controlled substance. You have the right to an attorney. Do you wish to have a lawyer?
If I can get one appointed to me.
Yes. Public Defender's Office is here. They'll be appointed to represent you.
Yes, Judge. I acknowledge receipt of a copy of the indictment, waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. General Bryson, you want that January 7th date? We're going to set you for status on January the 7th. If your case can be resolved either before then or by then, if not, we will give you a trial date on January the 7th. Your lawyer will be up to try to talk with you and get you ready for a disposition or for a trial. Thank you.
Yes, sir. Is there a way I can get a bond reduction?
Well, I'm going to let your lawyer talk to you. This is the beginning of our month in September, so your lawyer can talk with you about the bond issue, and if there needs to be a bond reduction or a bond motion, then they can file it for you, and then we'll set you for a hearing, okay?
Yes, sir.
All right, so they'll be up to talk with you about all those things.
Yes, sir.
All right, thank you. Mr. Spicer, you're here to be arraigned on a charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Public Defender's Office is here, and they will be appointed to represent you.
Your Honor, I acknowledge receiving a copy of the warrant, waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. We'll set you for hearing on September the 29th. Public Defender's Office has several attorneys. One of them will be up to talk with you about your case and get you ready for a hearing on September the 29th, okay?
Sir.
Thank you.
Thank you. All right, who's next?
Good morning. What is your name, please?
Stuart.
Mr. Stewart, you're here to be arraigned on an indictment charging you with theft of property with a value of $10,000 to $60,000, a Class C felony. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
And Public Defender's Office is here. They will be appointed to represent you. All right. Public Defender's Office has a conflict, so we will appoint Mr. Nathan Brown, who is not here at the moment, but I don't think.
What's the conflict?
Conflict is that they may represent one of the other defendants, or they may have represented one of the victims in the case or had some conflict in that way. They're not necessarily required to tell me what their conflict is, but the Code of Professional Responsibility requires them to advise me if they have a conflict that would prevent them from being able to ethically represent you. For example, you want a lawyer whose only concern is your best interest. You don't want a lawyer who's torn between whether this is going to benefit you or their other client. That's the whole idea behind a conflict of interest. So we're going to appoint Mr. Nathan Brown, who does not have that conflict. And standing in for Mr. Brown, would you, Mr. Talbot, please, for the indictment, for the arraignment?
Thank you, Your Honor. I acknowledge receiving a copy of the indictment, waive formal reading of the same, and on behalf of the defendant and his attorney, enter a plea of not guilty.
All right. Plea of not guilty is entered. General Wojnarowski, we're going to set this for January the 7th of 2026. Mr. Brown's going to be given a copy of these charges. He'll be up to talk with you as soon as he can arrange it and get you ready for either a disposition by an agreement at some point, or if you cannot resolve it by an agreement, then on January the 7th, I will set you a trial date.
All right.
All right, thank you. He'll be up to talk with you as soon as he can. Good morning. What is your name?
William Stout.
Mr. Stout, you're here today to be arraigned on a charge of possession of meth, possession with intent of more than 0.5 grams of a Schedule 1 drug, and cocaine, as well as fentanyl and drug paraphernalia. Count one is methamphetamine, more than 0.5 grams. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, please.
All right. Does the public defender know of any conflict you would have in this case? All right, public defender has a conflict. We will appoint Mr. Jacob Finley of the Clarksville Bar, Montgomery County Bar. He'll be notified of his appointment and be in to talk with you. You wish to stand in for him for arraignment?
Yes, sir.
Hand that to him.
Your Honor, I acknowledge receiving a copy of the indictment and waive formal reading of the same, and on behalf of the defendant and his attorney, enter a plea of not guilty.
Plea of not guilty is entered. We'll set it for status on January the 7th. That means your lawyer will be up to talk with you and see if he can get you, we have to advise him of his appointment, and then he will be, may need to make arrangements to come talk with you. And then once he has been able to talk with you, we will see if it's able to be resolved by an agreement. If not, on January the 7th of 2026, I will set you a trial date. So they'll be up to talk with you.
All right, thank you, sir.
Good morning. What is your name?
Larry Tanksley.
Larry Tanksley. Mr.
Yes,
Tanksley
sir.
will be arraigned on a charge of assault with bodily injury and theft. You have a lawyer named Roger Wainick that represents you. Is that correct?
Yes, sir.
All right. Mr. Wainick, has he filed a waiver? All right. Mr. Wainick is apparently in transit somewhere, so we'll allow that. Let's go ahead and stand in for arraignment. Since you have a lawyer, do you wish to have a formal reading of this indictment?
No, sir.
All right. Standing in for Mr. Wainick, the Public Defender's Office has waived the formal reading of the indictment, entered a plea of not guilty. General Sylvie, how do you wish to handle this scheduling?
Your Honor, if you want to go ahead and set it for a trial date.
All right. You want to set it for trial in January?
We'll go ahead and do that. That'll give Mr. Wayne enough time to get discovery and do that. So we can set it for trial in January with.
Well, that judge in January may not agree to that because of the fact that's contrary to his scheduling order.
Well,
I don't know. Yeah, he can be difficult to get along with sometimes, and I've heard, so do you,
I defer to the court then.
No.
Set it how.
to stay consistent with it, then we'll let Judge Wolfe set it for January the 7th for status, and if you don't resolve it on that day, we'll give you a trial date. So
Okay.
many days as we might have in January, we might be able to even try it in January, but I'd rather just put it for status right now. My rule is that, as you know, under this new process that I'm following, once we set it for trial, it goes to trial or they plead to the indictment and go to sentencing. So that's why I don't want to set it for trial in front of me unless.
That status date will be.
Right. Thank you. I know you want to stay on good terms with that judge anyway, so.
That is the state's motion to continue, Your Honor, and then we also have a 412 hearing set for today.
So the motion to continue, is there any opposition to the motion?
No, sir.
All right, do we need to go ahead and schedule for this month the 412 motion?
I've spoken
Is this
with,
the one where she's,
she just had the baby.
Okay.
Yes, sir. She stated that she's comfortable moving forward this afternoon with the 412, but for the trial, I think testifying about the actual event, she could not do. So we could do the 412 if the court would like to hear that today. I understand. Listen, it was motion to continue the trial, I think specifically is what I know
there's a lawyer's, when a lawyer comes in from a hard day in court and he sits behind his desk, and then the secretary comes in and says, do you want to talk to so-and-so client on the phone? I always used to say, that's the wrong question. Not do I want to talk to that person, but will I talk to
Will
that
you talk to
person?
that
So
person? I
when you
understand
ask me, do I want to do the 412 motion? It is not a question of whether I want to do the 412 motion. It's a question of whether I will do it.
Yes, sir.
We have another sentencing hearing that's set for this afternoon.
Okay.
I'm just wondering, we also have we have the 26th of this month. Is there anything set besides
make
Curtis
sure I'm
Day?
not-
I have a Curtis Day second-degree murder case that Mr. Atchison is involved in, and it's set for sentencing here in this courtroom on the 26th. So I'm just wondering if that might be a better day. If we don't have anything else set for that day, right?
The 26th is fine.
All right, let's set it for that morning at 9 o'clock. I think we'll do the Curtis Day, and then we can take this one up.
Okay, all right.
All right, so this one is Mr. Hansard's 412 motion. Is that the only thing that we'll be dealing with on that day?
Yes, sir.
Yes, sir.
Do we want to go ahead and set a trial date today, or would you like to get one?
I mean, that's fine. We can set a trial date. If you want to set one in January, then that might be the most appropriate.
Yes, sir.
We have given you trial dates. The conspiracy case general is still set for the 20th through the 23rd, correct? Is this a case, Mr. Hansard's case, one that we know for sure will go, and how long will it take to try it?
I think maybe a day and a half. I think it would
I think-
depend on how long jury selection.
And I
takes.
think 2 full days, Your Honor,
Yeah.
is my.
2 full days?
Just to be
expectation.
safe.
Yes, sir.
What about the 29th and 30th? I mean, we've got stuff set. That's the reason I don't want to set anything unless it's for sure going to go to trial. Right now, I've got the 13th. Greer. Sheets on the 14th. But if it's a 2-day trial, I don't want to set this one. So then we start the conspiracy case on the 20th, and it's going to go the whole week, correct? And are we trying it at some other venue? Are we trying it down in the jury assembly room where we can get all of the defendants in one location? Or are we looking for a gymnasium somewhere? In January, a football field will be a little bit dicey, I think, so. All right, well, why don't we just set this one? And let me just ask this. If I assign a trial date, everybody understands it's going to trial or he's pleading to every count of the indictment and going to sentencing. So with that, you understand that, Mr.
Understood,
Talbot?
Your Honor.
I will set it for January the 29th and 30th.
That hearing had a little bit of everything. Judge David Wolfe presided over a string of arraignments and scheduling matters. And while the charges ranged from probation violations to drug cases to theft, what stood out was his mix of firmness, patience, and even a touch of humor when the moment allowed Angele opened with Mr. Perez indicted for possession of Schedule 6 drugs, firearms during a dangerous felony, paraphernalia, and violating a no-contact order. He immediately requested a public defender, who entered a not guilty plea on his behalf. Judge Wolfe set a status date for January 7th, telling Perez his lawyer would discuss bond issues with him before then. Perez, polite but anxious, asked directly if he could get a bond reduction, and the judge answered pragmatically, "Talk with your lawyer. They'll file the motion if it's appropriate." His tone was firm but patient, reminding Perez this was just the first step. Next came Mr. Spicer, arraigned on a probation violation. Like Perez, he accepted appointed counsel and pled not guilty. Judge Wolfe set his hearing for September 29th, explaining clearly that one of the public defenders would be in touch before then. Spicer, subdued and cooperative, thanked the judge before stepping back. The docket then shifted to Mr. Stuart, indicted for theft of property valued at $10,000 to $60,000. Because of a conflict with the public defender's office, Judge Wolfe appointed Nathan Brown from the local bar to represent him. He took a moment to explain conflicts of interest in plain terms, noting that defendants deserve a lawyer whose only concern is your best interest. Stuart, respectful and attentive, nodded along as a stand-in attorney entered a not guilty plea for him. William Stout followed, facing multiple drug charges, including methamphetamine, cocaine, and fentanyl possession. Again, the public defender's office had a conflict, so Judge Wolfe appointed Jacob Finley. His explanation was the same: defendants deserve undivided loyalty, and Stout's plea was entered as not guilty. Finally came Larry Tanksley, charged with assault with bodily injury and theft. He already had private counsel, though his lawyer wasn't present at arraignment. Judge Wolfe accepted a not guilty plea through a stand-in attorney, then discussed scheduling with the prosecution. His candor slipped through when he joked about how difficult to get along with another judge's scheduling order could be, drawing a small chuckle before setting the case for status in January. The overall atmosphere was steady and procedural, but Judge Wolfe's candor and clarity stood out. Defendants were respectful and cooperative, some anxious, others subdued, but all left with clear timelines and instructions. The judge balanced professionalism with a touch of plain talk, patient in explaining rights, firm in setting deadlines, and even humorous when the situation allowed. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.